Good evening, all, and welcome to this very special webinar series for the book Sisters-in-Law. My name is Alan Frosch. I am a co-owner and the Chief Community Officer at Tattered Cover Bookstore here in Denver. It is a pleasure to welcome you all to this series. Want to, again, just remind everyone that this is the book around which this series and the play are based, and that book is available at Tattered Cover. It is really a pleasure for you all to be here tonight. I appreciate you all spending some time with us this evening. We'll get started in just one moment as people populate, but again, thank you all for being here. All right, as the rest of the attendees populate here, we'll go ahead and get started. Again, thank you for being here tonight. It's a pleasure to welcome you all. This Zoom is going to be viewed most effectively in gallery view, as we'll have a couple panelists speaking in conversation back and forth. Any questions you have for the panelists or for the moderator, please use either the Q&A function at the bottom of your Zoom screen or the chat function. You'll be able to send a question directly to the panelists using that chat function, and I will help Professor Norton moderate that Q&A at the end of the presentation. Again, we are very excited for you all to be here. It is my pleasure to introduce Diane Gilboa, the Artistic Producing Director at Theater Or here in Denver, and our partner on this Sisters-in-Law webinar series. Diane, take it away.
Thank you so much, Alan. For those of you unfamiliar with Theater Or, we're a small nonprofit theater company. We don't have a subscription base, and we produce 1 or 2 shows a year, preferably shows that you are not likely to see anywhere else. And this particular play, I don't believe you will be able to see anywhere else until it opens sometime next year off Broadway. Before I introduce our speaker, our moderator, I'd like to just take a moment and mention our webinar sponsors. And there are many, because we try to make all of our productions true community experiences. So our sponsors include the League of Women Voters, the Boulder Jewish Community Center, Brownstein Hyatt Farber Schreck LLP, Colorado Attorneys for the Arts, Colorado Bar Association, Colorado Women's Bar Association Foundation, the Denver Bar Association, Gibson, Dunn and Crutcher LLP. And here I have to give a special shout out to Gregory Kerwin and Jessica Brown of Gibson Dunn, because they were instrumental in helping us put these wonderful panelists together. The Mizell Arts and Culture Center at the J, the National Council of Jewish Women, Tierney Lawrence LLC, Universal Lending Corporation, and the University of Denver Sturm College of Law. And now I'd like to introduce our moderator for this session, Professor Helen Norton. She holds the Roth-Gerber Chair in Constitutional Law at the University School of Law. And before entering academia, Professor Norton served as Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice, and as Director of Legal and Public Policy at the National Partnership for Women and Families. She currently serves as Special Counsel on Constitutional and Civil Rights for Colorado's Attorney General, and is frequently invited to testify before Congress and federal agencies on civil rights law and policy issues. She holds a law degree from the Bolt Hall School of Law at the University of California at Berkeley, where she served as associate editor of the California Law Review, and a BA from Stanford, where she graduated with distinction. Her book, The Government Speech and the Constitution, has been published by Cambridge University Press, and her articles have been published in the Duke Law Journal, Northwestern University Law Review, Stanford Law Review Online, and the Supreme Court Review, among others. And I must add a final credit. She has been instrumental in helping us with a wonderful little artistic legal element in the show Sisters-in-Law. So thank you very much. And now I'd like to just turn it over to Professor Norton.
Thanks so much, Diane, and thanks to you, Ellen, as well. And thanks to everyone for sharing part of your evening with us tonight. So in tonight's discussion, we're going to be focusing on some of the major legal cases with which Justices O'Connor, Ginsburg were involved. And to lead tonight's discussion, we're deeply fortunate to have with us three justices from our own Colorado Supreme Court. I'm going to briefly introduce them, not doing justice to the full extent of their accomplishments. I'm going to introduce them in order of their seniority on the court. First, Justice Monica Marquez joined the court in 2010. And before joining the court, Justice Marquez served as Deputy Attorney General at the Colorado Attorney General's Office, where she led the State Services section in representing state executive branch agencies and also represented Colorado's statewide elected public officials. Justice Marquez also served as Assistant Solicitor General and as Assistant Attorney General in both the Public Officials Unit and the Criminal Appellate Section. Before joining the Attorney General's office, Justice Marquez practiced general commercial litigation and employment law at Holm, Roberts, and Owen. Justice Marquez grew up in Grand Junction, Colorado. She earned her bachelor's degree from Stanford University and then served in the Jesuit Volunteer Corps as a volunteer inner city school teacher and community organizer in Camden, New Jersey, as well as Philadelphia, before earning her law degree from Yale Law School. After she graduated, she clerked for Judge Michael Ponzer of the Federal District Court for the District of Massachusetts and for Judge David Abel of the United States Court of Appeals for the 10th Circuit here in Colorado. Next, we have Justice Melissa Hart, who joined the court in 2017. Prior to joining the court, Justice Hart was a professor at the University of Colorado School of Law, and there she directed the Byron White Center for the Study of American Constitutional Law. Throughout her time as a professor, Justice Hart maintained an active pro bono practice, writing amicus briefs in appellate courts and representing clients through Metro volunteer lawyers. Her teaching and her scholarship focused on access to justice issues, constitutional law, legal ethics, employment discrimination, and civil procedure. Justice Hart grew up in Denver, where she graduated from East High School. She earned her bachelor's degree from Harvard-Radcliffe and then spent a year teaching at a high school in Athens, Greece, before attending law school. After graduation, she clerked for Judge Guido Calabresi of the Second Circuit Court of Appeals, and then for Justice John Paul Stevens on the United States Supreme Court. She practiced law for several years in Washington, D.C., including as a trial attorney with the U.S. Department of Justice. Finally, Justice Maria Birkenkotter joined the court in 2020. Immediately prior to her appointment, Justice Birkenkotter handled complex mediations, arbitrations, and judge pro tem appointments at the Judicial Arbiter Group. From 2006 to 2017, Justice Birkenkotter was a district court judge in the 20th Judicial District, where she served as chief judge for the last 4 years of her tenure there. Prior to her appointment to the trial court bench, Justice Birkenkotter ran the Antitrust, Consumer Protection, and Tobacco litigation units at the Colorado Attorney General's Office, where her practice focused on national and local antitrust enforcement litigation. Before joining the Attorney General's Office, Justice Birkenkotter was in private practice at Holmes and Starr in Denver, Colorado. She clerked for Justice Howard Kirschbaum of the Colorado Supreme Court after graduating from the University of Denver Law School. So here's the plan for our discussion. First, each of the justices will speak for about 12 to 15 minutes each. We're going to start with Justice Hart, who will focus on Sandra Day O'Connor's opinions as a justice in the areas of federalism, which describes the relationship between the federal and state governments, as well as Justice O'Connor's opinions in the area of reproductive rights and affirmative action. Then we'll turn to Justice Birkenkotter, who will focus on Ruth Bader Ginsburg's work as a lawyer, where of course she was a path-breaking litigator in the field of gender discrimination and equality. And then finally, we'll turn to Justice Marquez, who will focus on Ginsburg's opinion as a justice in the areas of discrimination and equality. As Alan mentioned, please feel free to submit questions at any time in the Q&A or the chat functions. Alan and I will keep our eyes open for them. And I also may have a few follow-up questions for the panel as well. So Justice Hart, if you would please start us off.
Thank you so much, Professor Norton, and thank you, Alan and Diane and everyone who put this together. It's a lot of fun to think about these two extraordinary women and their impact on the law. So I am going first only because I'm talking about the first woman to join the United States Supreme Court. Sandra Day O'Connor was appointed in 1981. Before her appointment, she had a really different career than the career path of most of the justices who have served on the United States Supreme Court. She was first a state legislator, the head of the Republican Senate in the state of Arizona, and then an elected state trial court judge, and then ultimately an intermediate appellate court judge in Arizona. Those experiences, as I'll talk about, really shaped some of her approach to the jurisprudence that she is famous for on the United States Supreme Court. In her 24 years on the court, and really I think it was longer than 24, I think my math is off, I think it's 25 years on the court, she authored 645 opinions. There's no great way, obviously, to summarize all of those opinions, and it's hard even to really highlight all of the ones that were most influential because so many of them were so influential. But I'm going to use, as Professor Norton mentioned, 3 areas of the law to demonstrate how Justice O'Connor shaped the court to such an extent that it was not surprising in 2001, in the closing part of her career, that noted Supreme Court scholar Erwin Chemerinsky wrote that, quote, "This is now, without question, the Sandra Day O'Connor court. Out of tradition and deference to the chief, it is commonly referred to as the Rehnquist court. But let there be no mistake, for now a single justice, O'Connor, is in control. In virtually every area of constitutional law, her key 5th vote determines what will be the majority's position and what will be the dissent." It didn't start that way, though. And that's part of what's interesting about watching how she impacted the court's jurisprudence over her 25 years on the court. So I'm going to start with federalism. It's not surprising, given her past experience as a state legislator in particular, that O'Connor was a strong protector of states' rights, and in particular, the rights of the state legislatures, and skeptical about the federal government's potential for overreach. In 1982, during her first term on the court, so it was June of 82, she was appointed the previous summer, Justice O'Connor penned a strong partial dissent in a case called Federal Energy Regulatory Commission, or FERC, versus Mississippi. The case raised the question whether the federal government could require state utility commissions to consider adopting federal standards themselves. So Congress set out the standards and said, you state utility commissions, you must consider these. If the state regulators chose not to consider the federal standards and adopt them, federal law would kick in and preempt conflicting state law. The majority said this was an appropriate regulation of commerce, both under the Commerce Clause and also that it did not contravene the 10th Amendment. The 10th Amendment is the provision that says any powers not specifically given to the federal government stay with the states. And so the majority said it doesn't contravene the 10th Amendment by asserting federal power that is not specifically provided in the Constitution. Justice O'Connor dissented on that point, the 10th Amendment point. She argued that the 10th Amendment to the Constitution prohibited the federal government from, in her words, quote, conscripting state utility commissions into the national bureaucratic army. So her objection, as I said, was not to the standards themselves. She agreed that this is an area that Congress could regulate in, certainly. But her concern was that the federal government couldn't direct the state utility commissions that they had to consider these standards. Her concern was really substantially one about accountability. In her view, if the federal government directs the state government to adopt certain standards, to the public eye, it will seem that the state government was the one choosing the standards. The public looking for who's responsible for these rules is less likely to notice that it's a federal imposition of this requirement onto the states to consider because it's the states adopting the standards, and that's what people will see. As a former state legislator, she was no doubt keenly aware of the consequences of an unpopular regulatory choice for a local elected official, and that's what came across in her opinion. So that was 1982. A decade later, in New York versus United States, O'Connor converted her dissenting rationale in FERC, really the identical rationale, into a majority opinion for the court. In a 6-3 decision, O'Connor explained that in light of the 10th Amendment, a federal government cannot, quote, commandeer state governments into the service of federal regulatory purposes. This commandeering test was applied most famously in a case called Prince versus New York, which is the case that found that the Brady handgun bill was unconstitutional because it required local sheriffs to do federally mandated background checks. O'Connor did not author Prince, she joined the majority. And that perspective on the 10th Amendment was solidified into the court majority, and that has not changed. Another line of federalism jurisprudence in which O'Connor's dissenting perspective became the majority view is that of state sovereign immunity from federal lawsuits. In 1989, so almost a decade after she had joined the court majority held that federal Congress can abrogate, which is force a waiver of state sovereign immunity if the federal law clearly states that that's what it's doing, under any power that the federal government has. O'Connor joined Justice Scalia's strong dissent in that opinion, which was a 5-4 decision. And a series of cases through the 90s reversed that 1989 decision. And in 2000, Justice O'Connor wrote for a 5-justice majority in a case called Kimmel versus the Regents of the University of Florida that the federal government could not force states to submit to suits alleging age discrimination because Congress had not marshaled evidence of widespread constitutional violations by the states that would justify requiring the states to submit to these lawsuits. So again, it wasn't just that decision alone, but that perspective that O'Connor had at the beginning of her time in dissent became the majority opinion over her time on the court. There's really only one famous federalism case that Justice O'Connor lost, and I would say she lost the battle, but still won the war. In 1991, in a decision called Lopez, and then in 2000, in a decision called Morrison, Justice O'Connor was in the majority, seeing a very restricted Commerce Clause power, federal Commerce Clause power. In fact, in the preceding 60 years before Lopez, I believe my math is right there, the court had never found a case to be in excess of the federal government's Commerce Clause powers. But in these two cases, it did. However, in 2005, in a case called Gonzales versus Raich, which had to do with California's medical marijuana law, Justice O'Connor was not able to convince the majority that same principle from Lopez and Morrison, or the set of principles from Lopez and Morrison that restricted Congress's Commerce Clause power should apply to permit California to have medical marijuana, permit medical marijuana. And O'Connor, in her dissent in that case, really emphasized the idea that we've probably all heard of the states as laboratories of experimentation. And she said, you know, if she had been a legislator in California, she wouldn't have voted for a law that allowed medical marijuana. And if she had been a citizen, she wouldn't have voted for it by initiative. But as a judge on a federal court, she thought that it was her job to permit California to make its own mistakes. The court in that case said that the comprehensive regulation of drugs by the federal government meant that they could limit medical marijuana use in California. And we're still, by the way, living under that tension. It's only because the federal government chooses to let it happen that we have legalized marijuana in Colorado. So it's this interesting thing that's still sitting out there. Despite that loss, I think it's fair to say that O'Connor's approach to federalism really won the day, and that her influence as a state legislator coming in and talking about her experiences really shaped the court's perspective in important ways. Another context in which O'Connor's particular approach to a legal issue, again, first expressed in dissent, became the court's approach is abortion. Again, this issue arose early in O'Connor's tenure on the court. In fact, interestingly, abortion was a significant source of conflict during her confirmation. And the conflict was that anti-abortion right to life organizations did not have confidence that she would be an ally. They were very concerned that she would favor Roe versus Wade. And so there was tremendous pushback from that side of the debate about reproductive rights. She did not support Roe versus Wade, as it turned out, although she was not an absolute opponent. In 1983, in a case called City of Akron versus Akron Reproductive Health, in which the majority of the court disallowed a whole series of regulations that imposed limitations on a woman's right to obtain an abortion, Justice O'Connor dissented. And she said, Roe did not declare an unqualified constitutional right to an abortion. Instead, she wrote, the court's abortion cases have consistently concluded that regulation is unconstitutional only if it imposes a, quote, undue burden on a woman's right to seek an abortion. And one of the things that O'Connor did in this series of, in this opinion that was pretty common in her jurisprudence is that she redescribed the Supreme Court's jurisprudence and said, if you pick various pieces out of each of the cases in this abortion context, you can see this pattern of looking for an undue burden. So even though the court's cases had never previously used that term, and many people disagreed vehemently that that's what Roe versus Wade and in its subsequent cases stood for. She drew this through line through the cases and says that's what they mean. So 10 years later, in 1992, when Justice O'Connor co-authored Planned Parenthood versus Casey with Justice Kennedy and Justice Souter, the part of that opinion that she co-authored was the undue burden test that is now, for the time being, the law as applied to reproductive rights. So again, massive shaping of the court's jurisprudence, starting with her dissent and moving into the majority. And I think I'm running past my time, but I'll just say briefly, the same thing happened in the context of affirmative action. It's really quite striking how influential she was in this particular regard of convincing people to swing in her direction. In a 1985 case called Wygant versus City of Jackson, Justice O'Connor dissented to say all racial classifications by government must be subjected to constitutional strict scrutiny. There was no such thing as a racial classification that could be subjected to intermediate scrutiny. That was what the court was still holding in Wygant versus City of Jackson. Just a decade later in 1995, the majority of the court agreed with her in Adirond Construction versus Pena, a case from here in Colorado, which held finally that all racial classifications must be subject to strict scrutiny. But of course, the case that she's most famous for in the area of affirmative action, Gretna versus Bollinger, the 2003 case that upheld the University of Michigan Law School's admission standards, purported to apply strict scrutiny, but for one of the only times in history said, even subjecting this to strict scrutiny, we think that the law school's approach, taking race as one factor in an individualized assessment, survives strict scrutiny because it meets the compelling state interest of diversity in the educational setting, and it is sufficiently narrowly tailored to meet that compelling state interest. It was that case where Justice O'Connor famously said she thought we would probably need affirmative action in education for about 25 more years. This Thursday, when the court hears its long conference, that is the conference at the end of the summer to decide what cases to take, many people think they'll take an affirmative action case from Harvard undergraduate admissions that will in fact end affirmative action in less than 25 years. So that prediction may have been slightly off, but it has shaped the conversation on affirmative action throughout this century. And I'm going to stop there and turn things over to Justice Ginsburg and my colleagues.
Thank you so much, Justice Hart. Next is Justice Birkencotter, please.
You're on mute.
It's just like oral argument. Oh my goodness, that is the saying of 2020 and 2021. So before I dive in, I would like to thank Diane Gilboa and Jessica Brown and Alan Frosch and Professor Norton for inviting us to participate in this. It's a great opportunity, and it has really rekindled my interest in looking at some of, listening to rather, some of Justice Ginsburg's oral arguments. That has really been a gift. And if any of you have any spare time, even if it's just 10 minutes, that's all she had in Frontiera, because the time was split with her co-counsel. And it is just a remarkable performance. I'm going to talk about two different things. I'm going to start off and I'm going to talk a little bit about some context to try and help folks understand just how extraordinary Justice Ginsburg's work as an attorney was. I assume we have some folks in the audience who know a lot about her, and some folks who are newer to her jurisprudence, newer to her certainly as a practicing lawyer than as a justice. The second thing I'm going to do is talk about quickly about 7 cases that she argued or that she appeared in before the Supreme Court. Back in 1959, when Justice Ginsburg graduated from Columbia, I don't think that many folks could have imagined, even remotely, the trajectory of her career. There were very, very, very few women who were attorneys, and there were basically close to no women judges. Notwithstanding her extraordinary academic record, she had a difficult time finding a job after she graduated from law school. With the support and help of one of her mentors, I believe at Harvard, she eventually found a job working as a law clerk for a distinguished jurist in the Southern District of New York, and she went on to have a distinguished career in academia. Her interest in gender discrimination in particular, she has said in interviews, had much to do with her students' interest in the renewed women's movement, which sparked her interest in the renewed women's movement. Specifically, she was asked by a number of her students if she could teach a class on women in the law and gender discrimination. In 1972, she co-founded the Women's Rights Project at the ACLU. That same year, she accepted a job as the first female tenured law professor at Columbia. Justice Ginsburg was inspired by the work of Justice Thurgood Marshall, Charles Hamilton Houston, and the NAACP Legal Defense and Education Fund. By 1974, a mere 2 years after its founding, the WRP and the ACLU had participated or were participating in more than 300 gender discrimination cases. Justice Ginsburg, who I'm going to start referring to as Professor Ginsburg, just for the clarity purposes in my presentation, worked personally on approximately 34 cases in the Supreme Court. She argued 6 gender discrimination cases while at the ACLU, winning 5 out of those 6 cases. To give you some context, most lawyers never appear in front of the Supreme Court or brief anything in front of the Supreme Court ever. She was a brilliant strategist. She adopted and built upon the strategies that Justice Marshall had successfully implemented during his career. She was an incredible on-the-ground strategist. She was involved in every aspect of case development. She was involved in developing a huge pipeline to get cases to the WRP and the ACLU. She kept a comprehensive list of all past and pending sex discrimination cases, as well as lawyers who are willing to take those cases. She and the WRP shaped the gender equality litigation movement and its priorities, carefully selecting which cases to pursue, and just as importantly, selecting which cases not to pursue. She was in charge of the national communication strategy through WRP and wrote typed memos that she sent around to the ACLU affiliates around the country, instructing them on how to pursue follow-up litigation and to pursue legislative efforts and how to stay on message. She was also an architect, a publicist, an educator. She was a mobilizer for the gender equality movement. just as Justice Marshall had been for the civil rights movement a generation earlier. Justice Ginsburg believed social reform litigation was not just about winning cases in court, it was also about generating public support for social change. And to that end, she maintained a constant stream of correspondence regarding gender equality issues with student editors of the Law Review, with various media outlets, including the New York Times, with friends of hers who were on the bench and in legal academia. Now, when I say she maintained a constant stream of correspondence, I mean correspondence. This was before the internet, before computers, before smartphones. She typed out letters, wrote out letters, and mailed them. So when you think about sort of the breadth of the work and the depth of the work and the complexity of the mission and the idea that this was all done before the internet, I think it helps kind of helps you understand a little bit about just the extraordinary work that she did. All right, so let me turn to some of the cases that she litigated. The first brief that Professor Ginsburg, and I don't mean any disrespect, I just want to make it clear that for those folks who are not as familiar with the law, that at this point in time she was Professor Ginsburg. The first brief that she authored in the Supreme Court was in a case called Reed v. Reed. The case challenged an Idaho probate statute that presumed a preference for appointment of men as administrators of estates based on their gender. Excuse me. Before Reed, the Supreme Court had settled on the two-tier approach to equal protection cases. The first tier, the top tier, those cases challenging racial classification were the top tier and subject largely to strict scrutiny by the courts. The other tier, and that applied to almost all other classifications, including gender-based classifications, fell into the lower tier. Professor Ginsburg referred to that standard as the, quote, anything goes standard, because she believed that courts would accept almost any colorable rationale the government could offer in support of its classifications. One of Professor Ginsburg's most challenging things that she had to deal with in the 1970s when she was first appearing before the US Supreme Court was trying to convince the elderly male justices of the insidious consequences of gender-based classification. At the time, most legal scholars believed that the law should treat women differently in order to protect them. A key component of her litigation strategy was to focus on the double-edged sword of gender discrimination. That is, focus on statutes that tangibly discriminated against men, not women, though they intangibly harmed women by perpetuating stereotypes of female passivity and dependence. As a result, many of her cases involved gender discrimination against men. So turning back to Reed, Richard Reed was a minor who died with very few assets and without a will. His adoptive parents, who had separated sometime before his death, both applied to be the administrators of his estate, which was valued at less than $1,000. The probate court handled the conflict by appointing young Richard Reed's father because it read the controlling provisions of the Idaho probate code as compelling a preference for the father because he was male. In her brief, her first brief to the United States Supreme Court, Professor Ginsburg urged the court to adopt strict scrutiny, the higher standard of review. And while the court did not adopt Professor Ginsburg's proposed standard review, or for that matter, even refer to it, it did for the first time in its history strike down a gender line in a law as a violation of the Equal Protection Clause. The court also suggested a more skeptical approach to reviewing gender-based laws, requiring the government to prove the relation to be substantial, not merely rational. This shift by the court was the foundation for the argument Professor Ginsburg would make 2 years later in Frontiero, the first case she argued before the Supreme Court. Frontiero involved a military dependence allowance that favored military wives and disfavored military husbands. Specifically, Sharon Frontiero was a lieutenant in the United States Air Force. Her husband had been denied military housing and medical benefits. Federal law provided that military wives automatically became dependents and received those benefits, but applied a different standard, a higher standard for military husbands. The question litigated was whether federal law that required these different qualification criteria for males and female military spousal dependency unconstitutionally discriminated against women, thereby violating the Fifth Amendment's due process clause. Professor Ginsburg again urged the court to apply strict scrutiny as the standard of review, and the court ruled ultimately in Frontiero's favor, but could not agree on the standard of review. The plurality opinion by Justice Brennan applied strict scrutiny to gender-based classifications, but there were just 4 votes, not 5. And the concurring opinion that was authored by Justice Powell, those justices were not willing to go that far. They, among other things, cited to the fact that the Equal Rights Amendment, the ERA, had been passed by Congress or approved by Congress and submitted to the states for ratification. And in their view, in the view of the concurrence that is, it was inappropriate for the court to decide at that point in time whether sex was a suspect class. Turning to Kahn versus Sheevan, as a case that arose in the context of a Florida property tax exemption that favored widows, that is women, and disfavored widowers, that is men. This is the one case that Justice Ginsburg argued in the United States Supreme Court that she lost. It arose after widower Mel Kahn applied for the $500 property tax exemption that was available to widows under the Florida statute. His application as a widower, was denied. Professor Ginsburg signed on to work on the case apparently fairly reluctantly. It had not been vetted by the National ACU in the manner that it was supposed to, and it did not fit into her overarching litigation strategy as it related to these issues. To make matters worse, the local attorneys from Florida argued that rational basis, the lowest level of equal protection scrutiny, was the appropriate standard of review. So Professor Ginsburg was essentially stuck with that argument. The Supreme Court ultimately held that the Florida statute did not violate the Equal Protection Clause of the 14th Amendment. Justice Douglas, delivering the 6-3 opinion, held that the Florida statute had a fair and substantial regulation, the legislation's purpose of softening the greater hardship that women suffered upon the death of a spouse. Next, in Weisenfeld, that involved a challenge to a Social Security surviving spouse benefit that favored women and disfavored men. In that case, and I'm going to talk about this case, and then I think I will wrap up so I do not encroach on Justice Marquez's time. But in that case, after Stephen Weisenfeld's wife, Paula, died giving birth to their son, Stephen Weisenfeld was denied Social Security benefits available to sole surviving mothers with modest incomes. In 1973, Weisenfeld sued on behalf of himself and similarly situated widowers, arguing that the Social Security Act unfairly discriminated on the basis of gender. Because of the justice's reluctance to apply strict scrutiny, while the ERA appeared to be heading possibly toward ratification, Professor Ginsburg avoided the issue in Weisenfeld. She did not ask for strict scrutiny. Instead, she called for, quote, heightened scrutiny without further labeling. She used the case to show how a law purporting to benefit mothers by providing them with special benefits actually perpetrated and reinforced the stereotype that men belong at work and women belong at home. Specifically, she argued that Paula Weisenfeld was treated as though her work was of only secondary value to her family. Stephen Weisenfeld was treated as though he was not a capable and caring parent. And Jason Paul, a motherless infant, was treated as though he was not entitled to the personal care of his sole surviving parent. In practical effect, she said, quoting Justice Brennan and Frontiero, laws of this quality help to, quote, keep women not on the pedestal, but in a cage, close quote. The court struck the law down, holding that the gender-based distinction at issue violated the due process clause of the Fifth Amendment. Justice Brennan delivered the 8-0 majority opinion, holding that the purpose of the Social Security benefit for the surviving spouse is to enable that spouse to properly care for the children, regardless of the gender of the parent. The court ultimately held that Frontiero, not Kahn, controlled the equal protection analysis. So at that juncture, because I don't want to encroach on Justice Marquez's time, I'm going to go ahead and cut myself off. The only thing I'm going to add is that for those of you who think that her path may have been easy, this really grabbed me as I listened to oral argument. At the end of the argument, oral argument in the Durham versus Missouri case, which was in 1979, Justice Rehnquist commented at the end of Justice Ginsburg's oral argument, quote, "You won't settle for putting Susan B. Anthony on the new dollar, right?" Thank you.
Thank you so much, Justice Birkencotter. Justice Marquez, please bring us home.
All right, so I'm going to cover some of Justice Ginsburg's opinions. And of course, it's impossible in 12 minutes to cover the full contributions she made to the court's jurisprudence. And so in choosing to focus on just a couple of cases this evening, I drew from two aspects of my own experience as a Supreme Court justice, now 11 years into it. And that is bringing a different voice to the conversation and speaking in dissent. So let me unpack those two things. First, when I was appointed in 2010, I was 41 years old. I was a Latina, I still am, openly gay. That combination caught a lot of media attention. It also generated a lot of invitations to speak to community groups, women's groups, Latinx groups, LGBT groups, student groups, and so on. And appearing before those many different community groups, I realized, well, one, what a difference it made to many in those communities to have someone like me on the bench that people saw something of themselves in. And speaking to those groups, it forced me to think a lot about the importance of diversity on the bench, why it matters. There are a lot of reasons why it matters. Public perception that justice is truly equal for everyone. I don't think you can ever overestimate the power of having role models in positions of power and how important it is to dispel stereotypes. But I also came over time to recognize that at the actual decision-making level, it is important to have diverse voices in the room, to challenge each other, to see things from a different perspective. And Justice Birkencotter and Justice Hart and I and our colleagues do that on a daily basis. It is a challenging thing to work in a multi-member court with different work styles, different personalities, different philosophies, just different views of life. The truth is we judges all bring our life experience to the table. And by that, I mean everything that we know about the world, what we've experienced in the law, both personally and professionally. That also means necessarily that all of us judges bring our blind spots, our lack of certain experiences. And to me, that's one of the reasons it's so important to have diverse voices on a multi-member court. It makes a difference. It may not ultimately change the outcome in a given case, but it definitely enriches the discussion. And it certainly leads, in my view, to better, more thoughtful decision-making. Why? Because it ensures fewer blind spots. It makes sure that we bring a richness of life experience to the table. So with that in mind, I've chosen to focus on cases where Justice Ginsburg brought her life experience as a woman and her professional experience as a civil rights litigator to the table and lent a different voice to the conversation, sometimes in the majority, sometimes in dissent. Speaking of dissents, my second point. So I think it's important for anybody who's not a lawyer to recognize that when a justice is assigned a majority opinion, and typically it's the chief who does the assignment process, the justice doesn't go off and set about writing what he or she personally thinks the case, how it should come out. Rather, your task when you're assigned a majority opinion is to write for the court, to write for the majority in an event. And that can require some really expert navigation to hold on to a majority when it's a closely divided case, a willingness to bend a little bit, perhaps on your preferred views in order to hold that majority together. That is not true with a dissent. With a dissent, the justice isn't burdened by those requirements, and the justice can go ahead and say what she really thinks. So I think that anytime you're looking to see a justice's purest voice, go look at their dissents. Justice Ginsburg is known for her great dissents, so I focused on a couple of those because they represent her purest voice. But first, I want to start with a decision that I paid a lot of attention to in 1996 as a second-year law student, and that is the United States versus Virginia. So that's the Virginia Military or VMI case. So VMI was founded in 1839. It was a male-only public school designed to produce citizen soldiers, and it used what they called an adversative method designed to instill physical and mental discipline in its cadets. The students lived in barracks, they were under constant surveillance, there was never any privacy, they were basically hazed, harassed, tormented by upperclassmen in what was called the rat line for the freshmen. This school nevertheless produced many alumni who became great leaders in the military, in the government, and in business. So there was a female high school student who was seeking admission, and she filed a complaint. She was not allowed in because it was a male-only institution. She filed a complaint with the Attorney General of the United States, and the US then sued the Commonwealth of Virginia, alleging that VMI's exclusion of women violated equal protection. So the Supreme Court took up two issues. One, whether the exclusion of women from VMI in fact violated equal protection, and two, if so, what was the remedy? Is it to require VMI to admit women, or could the Commonwealth of Virginia essentially establish a standalone separate school for women, separate but equal program? So VMI asserted two basic justifications for its exclusion of women in this case. Single-sex education provides important educational benefits. And second, the school's unique adversative method would have to be modified if women were admitted to the program. So interesting backstory, and this comes out in the book, Sisters-in-Law, which I loved. At an initial vote after at the Justices Conference, apparently both Scalia and Chief Justice Rehnquist voted in favor of VMI. Now, when the Chief Justice isn't in the majority, that assignment privilege that I mentioned generally falls to the next most senior justice in the majority. That happened to be John Paul Stevens. The book says that John Paul Stevens believed that Rehnquist ultimately made the assignment in that case because he later changed his vote. But regardless of whether it was Rehnquist or John Paul Stevens, the initial assignment in that case actually went to Justice O'Connor, but she decided to turn it down. And according to the book, told whoever was assigning the case, this should be Ruth's. And so it was. So Virginia, Justice Ginsburg wrote for the majority. She held that Virginia failed to show, quote, an exceedingly persuasive justification for excluding women from VMI in violation of the Equal Protection Clause. Now, what's interesting about that language, exceedingly persuasive justification, is that it came from a case called Hogan versus Mississippi, where O'Connor had provided a crucial fifth vote to hold that Mississippi couldn't segregate the sexes in its public nursing schools. The book says that when Ginsburg actually read her opinion aloud from the bench, she mentioned Hogan right off the bat, and in so doing paused and looked up and met the gaze of her sister-in-law on the bench, Justice O'Connor. So what did she say in this opinion? She said that the state is allowed or required to show the differential treatment on the basis of sex serves an important governmental objective, and that the discriminatory means employed have to be substantially related to the achievement of that objective. She pointed out that classifications based on sex can be used, but they can't be used to perpetuate the legal, social, and economic inferiority of women. The court then rejected VMI's contention that its single-sex policy contributes to diversity in educational approaches. Even accepting that single-sex education can afford pedagogical benefits, at least to some students, Virginia had not established that VMI was established or maintained with a view toward diversifying educational opportunities within the Commonwealth when it was categorically excluding women from this program. It also rejected VMI's contention that the adversative method would have to be destroyed in order to accommodate women. And so Justice Ginsburg reasoned that this judgment is hardly different from other self-fulfilling prophecies that were once routinely used to not allow women to join the medical profession or not allow women to join the legal profession. So, quote, generalizations about the way women are and estimates of what is appropriate for most women just no longer justify denying opportunity to women whose talent and capacity place them outside the average description. In short, state can't exclude qualified individuals based on fixed notions about the roles and abilities of males and females. And surely in writing this, she drew upon her rich experience as a litigator and the architect of so much of this equality litigation for in support of women's rights. I want to move to a couple of her dissents. And the first one I'd like to talk about quickly here is Ledbetter versus Goodyear Tire from 2007. You've probably heard about the Lilly Ledbetter Equal Pay Act. Well, Lilly Ledbetter was a supervisor at the Goodyear rubber plant in Gabson, Alabama from 1979 until 1998. And at that plant, salaried employees like her were given or denied raises each year based on performance evaluations. So Ledbetter alleged that several supervisors in the past had given her poor evaluations based on her sex, and that as a result, over time, her pay had not increased as much as it would have had she not been discriminated against in those performance evaluations. So by the time she retired, years later, of course, the gap between her pay and her male counterpart's pay was pretty significant. So she filed a complaint with the EEOC in 1998, claiming a violation of Title VII. A jury actually found in her favor and awarded back pay and damages. But on appeal, Goodyear argued that her claim was time barred, meaning it was filed too late with respect to any of the pay decisions prior to 180 days before she filed her EEOC questionnaire. Why 180 days? Because that is the time limit that one is given under Title VII to file such a claim. So the majority in that case agreed and concluded that her claims were in fact time barred. That the time for filing a charge of employment discrimination, of course, begins when the discriminatory act occurs. Well, what's the discriminatory act here? The majority said, well, it's the act when the pay setting decision was made. So the point at which the performance evaluation was issued. And basically they concluded that Ledbetter was required to contest each one of those pay decisions within 180 days of the decision, and that she couldn't rely on a 1998 paycheck or her final paycheck, although it reflected that disparity, because it simply carried forward the past effects of discrimination. So Justice Ginsburg dissents. She was joined by Stephen Souter and Breyer, and she argued that the court was basically blind to the realities of pay disparities. Look, she said, a worker knows right off the bat if she's denied a promotion or a transfer, if she isn't hired or she's fired. But by contrast, pay disparities often occur in really small increments, and you might not even suspect that discrimination is at work until a certain amount of time has passed. You might not even have access to comparative pay information. It might be hidden from the employee's view. And importantly, you might not even appreciate that you have been subject to an adverse employment reaction if, for example, you get a pay raise, but it turns out your male counterpart also got a raise, but one that was simply higher. You think you're doing great because you've gotten a pay raise, but you don't realize that in fact, you have in fact been discriminated against. So Ginsburg asked, well, what is the activity we should really target here that qualifies as an unlawful employment practice? The majority focused on the pay setting decision, but Justice Ginsburg said, well, the actual payment is in fact a discriminatory wage. So under this approach, every time you get paid, that check is infected by discrimination, and that in and of itself is an unlawful employment practice. So here, the discrimination wasn't in fact at the past. Her very last paycheck itself revealed that discrimination. She had alleged that, the jury found that. Goodyear continued to treat her differently after each pay period, and each time with mounting harm. So what I found cool about this dissent is Justices often write with a particular audience in mind, particularly in dissent. And then this particular dissent was targeted directly at Congress. And in fact, she comes out in the last paragraph saying, once again, the ball is in Congress's court. As in 1991, with the Civil Rights Act of that year, the legislature can act to correct this court's parsimonious reading of Title VII. And 2 years later, Congress responded with the Ledbetter Fair Pay Act of 2009. This stated that the 180-day statute of limitations for filing an equal pay lawsuit resets with each new paycheck. So essentially adopting Justice Ginsburg theory of how this whole thing ought to work. I'd like to quickly move to Shelby County versus Holder, a 2013 decision. This involves the Voting Rights Act of 1965. As you are probably aware, that act was enacted to address racial discrimination in voting. Now, Section 2 of that act bans any standard practice or procedure that results in the denial or abridgment of the right of any citizen to vote on the account of race or color. Section 2 applies nationwide and it is permanent. Differently is Section 4 and Section 5 of the Act. So Section 4 of the Voting Rights Act only applies to certain parts of the country. Section 4 provides this coverage formula that defines certain covered jurisdictions that are subject to pre-clearance requirements. The pre-clearance requirements are set forth in Section 5, and Section 5 says then that no change can be made to certain voting procedures unless that jurisdiction gets that plan approved by federal authorities, which process is known as pre-clearance. So these coverage formula that appeared in Section 4 applied to certain jurisdictions, states largely in the South, that had a history of discriminatory voting laws. So Congress re-upped this Voting Rights Act provision, including the formula that had been set in place at its original enactment. And Shelby County, Alabama, brought suit seeking a declaration that the Voting Rights Act's coverage formula and this pre-clearance requirement were unconstitutional. Chief Justice Roberts, writing for the majority, held that the coverage formula was in fact unconstitutional. It started with the idea that states retain broad sovereign authority to pursue their own legislative objectives, and that the Voting Rights Act arguably encroached upon some of that sovereign authority. It did recognize that in the 1960s, the original coverage formula made sense, and it targeted states where there had been overt voting discrimination. But in the majority's view, times had changed, and past discriminatory practices no longer justified continued federal oversight of these particular jurisdictions. So Congress's reauthorization of that coverage formula was unjustified. And interestingly, the court focused to sort of point out discrimination is no longer an issue. It focused on rising voter registration and turnout rates among Blacks in those covered jurisdictions. It pointed out, though, that Congress had not tweaked or altered this 40-year-old coverage formula. So looking at this old formula, it just concluded that that old formula was no longer justified, and it struck down the coverage formula in Section 4 as unconstitutional. Now, technically, it left preclearance in Section 5 in place, but without the coverage formula, Section 5 ultimately served no purpose. So when people say it gutted the preclearance, that's what they're talking about. Justice Ginsburg dissented along with Breyer, Sotomayor, and Kagan. And she began by stating that according to the majority, the very success of the Voting Rights Act demands its dormancy. Though conditions in the South have impressively improved, Congress has now found that the Voting Rights Act was still the driving force behind that improvement. Congress had developed a substantial record supporting this coverage formula and preclearance. And given that substantial record and the great discretion that the court should be giving Congress in this area to enforce civil rights amendments, Section 4 was surely within Congress's power to reauthorize. Now, throughout this opinion, Ginsburg highlighted what she referred to as second-generation barriers to voting. Unlike earlier barriers in the 1960s, which directly denied minority voter access to the polls, these barriers often work to dilute minority vote, be it through redistricting processes or shifting from district process to at-large voting processes. when you have a jurisdiction with a sizable minority population. All of those kinds of shifts in election procedures can actually dilute the minority vote. So she took the majority to task as being wrong to focus solely on rising voter registration and turnout, saying what we really need to look at is what sorts of pre-clearance challenges were raised and what did the Department of Justice actually put a stop to. Turns out that between 1982 and 2006, the Department of Justice blocked over 700 changes based on a determination that those changes were discriminatory. Her point being, pre-clearance was still very much serving a deterrent purpose. So the line at the end that is often quoted, which I think makes a lot of sense, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. In other words, she accused the majority of saying, gosh, we're dry under here. It must have stopped raining. When instead, the reason they were not getting wet is because the pre-clearance requirement umbrella was actually functioning as designed. As we know, right now, the country is awash with all kinds of interesting changes to voting rights and election procedures. And so it'll be an interesting discussion as we move forward, how those types of laws are viewed. And I'm going to wrap up there because I have gone on far too long. So I'm going to hand it back to Helen.
Thank you so much, Justice Marquez, and thanks to all three of you for wonderful and really exceptionally thoughtful remarks. Again, we'll invite the audience to submit any questions in the Q&A or the chat function, and we'll do our best to get to them. But I have some questions of my own. I guess what I'd like to do is to give each of the three panelists the opportunity to engage with any of the other panelists' observations, or if you'd like to elaborate on something that you wish you had more time on. And I would like to invite you to talk about anything you want to talk about, because so far you've been riveting. I'll suggest a couple of possibilities for your consideration and rejection. Justice Hart, for example, we've heard Justice Birkenkotter and Justice Marquez focus on Justice Ginsburg's equality law work, both as a litigator and as a justice, right? Understandably so, because of her leadership in that field. Justice O'Connor's equality law jurisprudence is less well known, but still important. So I'd invite you to consider addressing that. And Justices Birkenkotter and Marquez, Justice Hart focused on Justice O'Connor's federalism jurisprudence, where she was very influential, and her work was informed by her extensive experience in state government. And both of you have extensive experience representing the state of Colorado. So I'd invite you to, if you care to weigh in on either Justice O'Connor's or Justice Ginsburg's federalism views. Justice Ginsburg's views were quite different from Justice O'Connor. But again, whatever you'd like to address. Justice Hart, I'll start with you.
Sure, thanks so much, Professor Norton. So a couple of things that I think stand out to me. First, it's interesting, Justice Ginsburg, I just want to comment on Professor Marquez's points about Justice Ginsburg's dissents, for which she is rightly famous. Justice O'Connor's dissents, because of timing and how the court changed around them over the years, her dissents didn't have this sort of public power that Justice Ginsburg's did. You didn't hear a lot of conversation about Justice O'Connor's dissents in newspaper editorials, and yet, as I sort of talked about before, and I won't rehash it, but they did end up having an incredible impact on the court as the composition of the court changed. And I think it's another way in which dissents can be so important, is they stake out positions for the future, if you're so fortunate as to be in a position in the future to change that perspective. I also think one of the things that's interesting about Justice O'Connor's opinions, there's one, Justice Marquez mentioned Mississippi University for Women versus Hogan. And what was interesting about that decision is Mississippi University for Women was a nursing school that had a women-only admission policy, so very different from VMI. And Hogan, the individual in that case, was a man who wanted to get a degree from the nursing school, and he sued, saying he had a right to be able to go to that school. And Justice O'Connor's opinion for the court saying that that was a violation of the Equal Protection Clause for Mississippi to have a policy that men couldn't be admitted, focused on the idea that there is no, we don't need to have special education for women in the area of nursing because there's already a stereotype that nurses are women. And so it's not that there's no compelling state interest in perpetuating that stereotype. In fact, if anything, it's the opposite. And another opinion she's really famous for in the area of employment discrimination is her concurring opinion in a case called Pricewaterhouse versus Hopkins, which is a case that famously set out the notion that sex stereotyping could be proof of sex discrimination. And it was an opinion that was divided in multiple ways, as US Supreme Court opinions often are. And so when people tried to figure out, okay, what's the majority opinion here? They often looked to O'Connor's separate concurrence, where she was very cautious about what kinds of evidence you have to prove sex stereotyping. So she was both very early on aware of the idea that stereotyping was a problem. And again, I think for both of these women, both of whom faced incredible challenges when they came out of law school, they were so steeped in the reality that stereotyping was a really significant problem that it had to inform their jurisprudence. But she was cautious about taking that too far and wanted to put limits on it because it risks, from her perspective, it risked being a very expansive possibility, a very expensive litigation possibility. So to me, that's one of the more interesting sort of things to look at, and how, again, comparing the two. RBG, the notorious RBG, is notorious. She's a feminist icon. O'Connor, I think, sometimes doesn't get enough credit for her extraordinary feminist achievements. Some of that might be because I'm not sure she would claim them as feminist achievements. And some of it was because she was just more cautious about how she viewed it.
Thank you. Justice Birkencotter.
Oh my goodness. I'm gonna punt and go to the question in the chat. Diane says there was a question about how the decisions of these justices affected the panelists personally. And one of the things I reflected on, and this doesn't quite answer this question either, but as I was looking through this and you know, sort of the background materials and listening to some of the oral arguments, when Justice Ginsburg graduated from law school from Columbia after she transferred from Harvard, it was 1959. None of us were born yet. When Justice Ginsburg first appeared in front of the United States Supreme Court, the newest justice on the court, Amy Coney Barrett, was not born yet. It's interesting, and that segues sort of awkwardly to the answer to the question, which is, I think that so many of the things that they did affected all of our lives so profoundly. It's hard to scratch the surface in the amount of time. I mean, I think we've talked about some of the cases, just the extraordinary lives that they led. And I have to say, for me personally, one of the things I'm drawn to with respect to both of them in terms of their personal stories, but it's so different for both of them, are sort of the lives they've led. And they were very, I mean, not only were they brilliant and extraordinary thinkers, but they were so strategic. I mean, they were, but in very, very different ways, right? If you look at Justice O'Connor throughout her career, you know, she would sort of run into one roadblock after another, and she'd bounce and she'd open up her own practice, and then she'd run for the legislature, and then, you know, I mean, sort of all these things, you know, writing to the president, you know, to urge him at various times to put a woman on the court. Interesting. And then Justice Ginsburg, you look at her work in terms of gender discrimination litigation, and it's mind-blowing in terms of sort of her strategic skill, particularly as I highlighted at a time when, you know, she didn't have the tools available to her, and the WRP didn't have the tools available that we have now. So that affects me personally. It's not a particular case, but it's inspiring.
Thank you. Justice Marquez.
I guess I'll pick up on where Justice Birkencotter left off and just say, I read the book a few years ago when it first came out, and actually enjoyed it as an audiobook, which was a wonderful way to experience it. And I think having served on a multi-member state Supreme Court at that time, having been at different points during my tenure, part of a group of 3 women and then part of a group of 2, and what a difference it makes when there's a huge difference, honestly, between a 4-3 breakdown and a 5-2 breakdown. And I'm smiling at Melissa because she was one of that twosome before we gained Maria and made it 3. Navigating those dynamics is so challenging, and just sort of drawing from my own experience and thinking about how much exponentially more challenging it must have been for O'Connor and then Ginsburg to join with O'Connor and then lose her and be by herself for many years. Just how profoundly personally challenging that must have been. So I draw inspiration from that. I draw inspiration from their 2 very different styles to approaching that change. O'Connor coming from this very practical, no nonsense Western sensibility, slightly more political approach, and then Ginsburg just this laser sharp, strategic architect of this whole coherent scheme, a way of thinking about these cases and building on them one step at a time throughout her legal career, and then actually being able to cite her own work as a justice, how powerful that is. So it was a particularly neat experience for me, just given what I do every day, to think about these women and think about them and their roles, and how much of an impact they've had on so many of us. So.
Justice Hart, did you want to respond to that question? How have their legacies affected you personally?
Sure. So, so Justice Ginsburg, I think I try to model my approach to when to dissent after Justice Ginsburg's view. She, I think, really powerfully said, dissents speak to the future. That you're not dissenting just to express your disagreement. You're dissenting because you think something could change in the future. And I've really tried to choose not to dissent when I don't think it matters for the future, to choose to look for a more unified court, which I think has real value, unless I think it really matters. And I can hear her voice in my head whenever I'm sort of trying to go back and forth and decide. And just for fun, I'm going to say O'Connor affected me not so much through her decisions, but for some of you may know that Justice O'Connor, during her years on the court, she had an aerobics class that she ran. On the 4th floor of the court, there's a basketball court and a gym, and she ran an aerobics class for the women at the court. And one of my best friends was one of O'Connor's clerks, and so she enlisted me into going to Justice O'Connor's aerobics classes. And some of my funniest, truly ludicrous stories from my year clerking with Justice Stevens come from moments in Justice O'Connor's aerobics class. So I think that that's, I can make myself laugh sitting in my car driving, just thinking about some of the silly conversations that I had with her over aerobics. So it's not one of her decisions, but it's how I will always think of her.
That might be an appropriate way to start to wrap things up. I think we advertised a 7:45 stop time. I want to give the justices a chance for any last remarks, and then turn it over to Diane and Alan to close things out. Any of the justices, anything else that you would want to make sure we think about or talk about? All right, Alan and Diane, please.
Thank you all. What an incredible presentation. Just expertise and thoughtfulness, and incredible testament to the legacies of these 2 great justices and you 3 great justices. So thank you very much for serving our state and for being here tonight with us. And Professor Norton, thank you so much for guiding us through this conversation expertly and aptly. So again, thank you 4 women very much for making this a really valuable and excellent presentation. So this is the third in the 5-part series of Sisters-in-Law. The link to the website that shows the schedule and the panelists for future series is in the chat. We are very excited for the next series, the next event, which will be October 4th. It'll be on the legacy of these two justices in our legal system, in society, et cetera. It's going to be a great presentation. We're very excited about that. For future other Tattered Cover events, please visit tatteredcover.com/event for our event calendar. Again, you can get the book Sisters-in-Law at Tattered Cover. Excellent read, as Justice mentioned, very important stories about these two women, their friendship, their professional friendship, and their alliance in terms of jurisprudence. Very thoughtful, excellent book. And again, we are thrilled to have this in the third of 5 series on this webinar. Thank you all for being here. Take care, and we'll talk to you soon. Thank you.
Thanks, Helen.